We are pleased to welcome our next speaker, Mr. Harsh Mahaseth, a distinguished academic and legal scholar from Nepal, currently serving as an associate professor and research fellow at the Center for Alternative Dispute Resolution, Jindal Global Law School, OP Jindal University. With a specialization in public international law and Asian legal studies, Mr. Mahaseth has taught a leading institution including Nalsar University of Law and Mahindra University and is recognized as one of the top cited international law scholars in India. He is the co-founder of College Get, a platform supporting students in their academic journeys abroad, and has held key administrative roles such as assistant dean and assistant director at JGU. A graduate from National University of Singapore and NALSA, with additional diplomas in diplomacy and journalism, he has authored over 50 peer-reviewed journal articles and 175 publications in global media. We are honored to welcome Mr. Harsh Mahaseth to share his insights on ADR landscape in Nepal and to contribute richly to today's discussion. Over to you, sir.
Thank you so much. Namaste, everyone. My name is Harsh Mahaset, and thank you for the lovely introduction. And thank you so much to Inda Vijayan sir as well as KFCRI for this invitation to talk about Nepal's role in international arbitration. If I might ask, will I be allowed to share my screen or will I just ask for the next slide to come on?
I think we will assist you in changing the slides, sir.
Okay, sure. Then, if that is the case, just give me a minute because I had a couple of links open. So, just to give you a bit of background about Nepal so that you can understand more about where we are located as well as some of the context. Nepal is a landlocked country which is sandwiched between two major countries, India and China, which is the first piece of information. The second, which is important and also I think quite similar to our previous speaker, Professor O, is also that a lot of work that happens in Nepal happens in our national language, in Nepalese. And unfortunately, until now, a major part of it still continues to happen in our national language, Nepalese. And so, even for that, if we have a look at, if you could maybe just go to the next slide, because the next slide just talks about the 5 pointers that I was supposed to look at. Yes. So, in this, if we have a look at the third point, which is influential rulings by local courts, all of this is very tough to access as well for anyone from outside of Nepal or that does not know the Nepalese language because all the court rulings would be in Nepali. I have added a few of them in my presentation as well. Hopefully, that is of help to understand more about Nepal. And the third thing to understand about Nepal is that we run on a specific calendar called the Bikram Sambat calendar, and that is going to be useful over here because the years that you will be seeing in our acts will be different from the usual AD years that you will be seeing. Because in Bikram Sambat calendar, we are already in 2082. So when we have a look at our act over here, you might see 2055 or 65. So I will try to give you the approximate year in AD as well in such circumstances to hopefully to ease things through. That being said, if we have a look at the neighboring countries in Asia, specifically South Asia or Southeast Asia, we would see that many countries do have very prominent roles in international arbitration. So, to give the example, India has a very robust arbitration situation scene. If we look at Southeast Asia, we would see Singapore with SIAC, Thailand with THIAC, as well as Malaysia with KLIAC. In comparison, Nepal does not have that robust of a place for international arbitration. However, that has been growing over the past few years. So, could you please go to the next slide? Do I have access to go to the next slide? Because I'm not sure where we are right now. If someone can confirm, am I on the overview PPT slide right now? I just moved it forward.
Sorry to interrupt, sir. Actually, it's a small technical glitch. Please give me a minute.
Okay,
Yeah.
sure.
Sir, is the slide visible?
Yes, it is.
Thank you, sir.
Okay, thank you so much. So, as we can see from the overview, Nepal has seen an increasing engagement in global legal and economic frameworks, as well as because of this, we do see growing importance being given to international arbitration. And interestingly, we do see both the public as well as private sectors uh, gradually becoming arbitration aware, as I will show you in the coming slides. We do have government agencies and state-owned enterprises who have started to increasingly incorporate arbitration clauses in their cross-border contracts. Specifically, certain areas have started doing this. As you can see, construction, hydropower, telecommunication are some areas where we have seen this growing importance being given to international arbitration. And of course, this shift does reflect a growing confidence in arbitration's efficiency and neutrality compared to the traditional court litigation. And to give you the fact scenario, there is a lot of delays that are suffered in traditional court litigation, due to which we see the growing need for arbitration. Can you go to the next slide? Um, yes, thank you. And I am just giving a caveat. I was here for most of Professor O's lecture as well, and he had a really lovely PPT. Unfortunately, mine is a very basic PPT that I use, which will basically just have the title as well as some of the facts. So apologies in advance for that. So coming back, if we have a look at the public sector involvement and private sector involvement, in public sector, we do see that the government is seen as a party in some occasional involvement in investment treaty disputes. We do see some state-owned enterprises as well in a limited capacity, in very few instances right now. However, that is an emerging area where there has been more involvement over time. And there are ongoing updates to our arbitration laws. There is an institutional role as the government has put in efforts to promote Kathmandu as a potential hub for regional arbitration. While talking about that, in 2013, we did start the Kathmandu International Arbitration Center, KIAC. And when we're talking about ongoing updates, as you will see in the coming slides, there has been a recent update to our Arbitration Act, which is the Arbitration 2025 Ordinance. So I will be getting into that very slightly in the coming slides. So can you move to the next slide? Thank you. So while we have seen public sector involvement, there is definitely a huge private sector involvement as well, as we do see the increasing use of arbitration clauses in international commercial contracts. And as I had given examples, construction, energy, and telecommunication sectors are some of those sectors. Not just that, we do now see law firms and professionals have started specializing and gaining expertise in international arbitration practices. A lot of my colleagues, as well as juniors from college, have now started working in arbitration in Kathmandu itself. And it's not just that, but even Nepalese businesses are also increasingly involved in cross-border transactions, which has led to their participation in foreign administered arbitration proceedings. Now, while talking about foreign administered arbitration proceedings, we do see a lot of these cases being handled by the International Chamber of Commerce or the Singapore International Arbitration Center. And while this does show the importance of having clear arbitration clauses as well as a growing understanding of the arbitration norms amongst these Nepalese parties, we do see that most of these cases are going to SIAC or other arbitration centers rather than staying within Nepal itself. Um, However, that being said, thank you so much for changing the slide. That being said, we do see that Nepal has seen the increased use of arbitration in construction, hydropower, infrastructure, telecommunication, and there has been this gradual shift from litigation to arbitration in commercial contracts. That being said, one very interesting thing I was just discussing with a couple of my colleagues a few days ago was with respect to the cases that come in front of the KIAC or in Nepal itself. Very interestingly, as I did mention that all of our laws as well as all of our judgments, everything, the entire process happens in our national language, Nepalese. Interestingly, arbitration, when we do go to arbitration, it can be decided either in English or in Nepali. And that all depends upon what the contract stipulates. So if the contract stipulates that it has to go to arbitration, and if they specify it has to go in a specific language, English or Nepali, that will take precedence over the Nepalese language, even if the contract says it has to go to arbitration and the language will be English. However, if there is no clause, then if both of the parties decide that it will go in Nepali, it will go ahead in Nepali. Can you go back? Thank you. So, that being said, there is greater awareness and training among legal professionals and corporate councils, the Nepal Bar Association, our bar council, and a lot of academic institutions are increasingly offer ADR focused programs. I think just last month we had a program for developing ADR skills in which a lot of organizations as well as law schools are organizing these programs, not only for the law students, but also for advocates so that they are also increasingly aware about the different methods that are available under ADR. Now, these programs usually do invite all of these councils as well as, let's say, academics, judges who all know about ADR procedures to train all the students as well as other lawyers. And very interestingly, this has been happening nearly every month to alternate month now. And with that, we do see this increasing push towards ADR focused programs. Not just that, unlike our neighbors in India, where alternate dispute resolution as well as mediation have become core courses that have been mandated, in Nepal, we do not see that right now. We have started to see courses on ADR in the past few years, which I think is a positive aspect. However, there is still a lot that needs to be done. And of course, as you can see, there has been a push for digitalization and the use of online hearings post-COVID-19. And as I was mentioning, there is a new ordinance that has been promulgated this year itself, just a few months back. And could you move to the next slide now? Yes. If we have a look at our framework, the Arbitration Act of 1999, which is based on unset trial model, however, there are of course gaps in this. Nepal became a signatory and there was accession in 1998. This enables recognition and enforcement of foreign awards. So apart from the 1999 Act, we also do have our Mediation Act of 2011, which is a very interesting act if you have a look at it. I had just done some research on the Mediation Act as well. However, it does complement ADR in Nepal, after which we do see the Arbitration Ordinance of 2025. There are several changes that have happened over the past 26 years. However, the latest ordinance is of 2025. And as I was mentioning, the Kathmandu Center for International Arbitration, apologies, was established in 2013. And while it had aimed to serve as a hub for regional and international commercial disputes, it is still in its very early nascent stages of development and recognition, and has not been able to establish itself so much as the other neighboring countries that I did talk about in South and Southeast Asia. However, it is on track for that. If you can move ahead. Can you go to the next? Yes, thank you. So that being said, I was asked to look at a couple of influential local court rulings in which I have given three specific case laws. And over here, as you can see, this is what I was mentioning. The case, which is Bridgeline Corporation versus Agricultural Input Corporation, is a 2062 case. 2062 is Bikram Sambat. And since we are in 2082, we are minusing 62 from that. So this is 20 years back. So if you have a look at our judgments, we do have judgments from a few decades ago. And from this one, which I would say is the earliest one to look at, till what is happening right now. And the reason I was talking about how I selected three specific case laws and why these are important is also because, as I mentioned, all of our judgments are in Nepali, and this is just a basic translation or just my understanding. And also, I think this one is from a specific author that I had seen who had written about the specific topic as well. So I have compiled these three landmark cases that I thought are influential local court rulings that impact arbitration. So this first one, Ridgeline Corporation, if we have a look, the court has interpreted the existing arbitration laws and set a good precedent. So while rejecting writ petition, the court held that so long as there is an alternative provided for in the law, writ jurisdiction should not be invoked as a usual course of action. And so the Supreme Court held that it can entertain application or appeal only against the appellate court order or decisions. If you can move to the next one. I do see that I'm running out of time, so I'll just try to finish this in the next 1 or 2 minutes. This case of 2067, which would be 15 years ago, of Department of Road versus Viva Construction, held that where the dispute is to be resolved through arbitration, the court cannot enter into the factual questions, consider the evidence, and provide a decision in a manner similar to a normal case. So Supreme Court held that where there has not been any grave error in law, the court cannot invalidate an arbitral award. And if you can move to the next one. Over here, I'd also provided a link to the arbitration law in English. So this specific case, which is 2077, 5 years back, some would be 2020, which is Department of Roads versus Arbitral Tribunal, comprising of Mr. Sureshman Shrestha, Mr. Kamla Upreti, and Mr. Narendra Kumar Shrestha. The Supreme Court over here held that the court has the authority to invalidate an arbitral award and revert matter back to arbitration only under specific circumstances which are found within our Arbitration Act. And that is the link over there that I was going to open it and show you those. However, my slides will be available to all of you, hopefully, and you can have a look at this. Due to paucity of time, we will not be opening up that link. So if you can just move ahead, and I'll just move to, can you, yes. There are a lot of challenges to international arbitration in Nepal. It is facing significant challenges due to limited institutional support and infrastructure. The country also quite lacks a robust and widely recognized arbitration center, which is capable of handling complex or high-value disputes, as well as there being a limited pool of experienced arbitrators and trained legal experts. Due to which, as you had seen in a few slides before, a lot of parties do prefer going to, let's say, SIAC, and which leads to higher costs and also limited opportunities for local capacity building. Not just that, there are also judicial delays, as I was mentioning, as well as unpredictability in enforcement of these arbitral awards, as well as a lot of gaps within our own act as well. And there is a reluctance amongst domestic parties to opt for arbitration because a lot of parties do not still understand or they're quite unfamiliar with the concept. So if you can just move ahead. However, that being said, there are a lot of opportunities in Nepal because we have seen an increase, as I was mentioning, in the conferences, workshops, as well as capacity building programs, not done only by the Nepal Bar Council, but also by leading law schools as well as by organizations that bring together not only law students and lawyers, but also judges and academics. And as I mentioned, several law schools have also started to add ADR courses and even promote ADR competitions. And with that being said, there is a need to develop a strong and independent arbitration institution in Nepal. And we have seen a good start to that. And we do see a great progress coming over the years. And with that, there is just hope that this continues. And with more knowledge, more awareness, and more capacity building programs, we can see the international arbitration scene as well as the, in general, ADR scene in Nepal grow in the coming years. So thank you so much. Namaste. I thank you so much for inviting me, sir.
Thank you, Professor Harsh, for the insightful information about arbitration in Nepal. An interesting thing to share with you. I recently had a visit to Nepal for the Nepal ADR week, which was initiated by the Nepal International Arbitration Center. And significantly, multiple arbitration institutions in Nepal joined hands together and just structured that. And the takeaway was being a very landlocked country, as you rightly started with. Nepal wanted to initiate this green protocol in arbitration. And there was a declaration given on the end of that particular week stating that every Nepal arbitration institution, Nepal arbitration practitioners predominantly wanted to go for green protocol or green arbitration, a very interesting initiative wherein Nepal is going to be a major stakeholder in it. In my personal note, what I feel being a neighboring country and Nepal being part of the SAARC regional arrangement, there was one council, if in your research you can further stretch on it. It was called the SAARC Arbitration Council, which was initiated by all the member states in the South Asian region, wherein it wanted to bring in not only the arbitration institutions, the academic units, as well as the sovereign states in South Asia, to have a common legislations for arbitration. That was an initiative taken by SAARC Council, but for what reasons, it's yet to take off. But interestingly, the development, what you highlighted in Nepal regarding the growth, the significance, the uniqueness in Nepal arbitration arena, particularly the ADR arena, it was a good note from the government. The government had the initiative. The government is very keen that not only Nepal is good for spiritual tourism or for the general tourism or the wonderful opening to the world tallest peak. Why can't Nepal become a hub for arbitration? Not only in the context of international arbitration, but also in a green international arbitrations. And in that initiative, I feel it is very much required that we as an institution based in Global South and Nepal being a significant player in the global south, we have to partner in a way how it has to be, so that the path has to lead that every parties, whether it's a Nepali party or the Indian party or the parties from global south, have to consider the seats, not only Kathmandu. Kathmandu being quite vulnerable for multiple reasons, particularly on the geological issues. We have the multiple arena in Nepal itself. There are multiple regions in Nepal wherein the court system as well as the legal systems are facilitating to make Nepal as a country to be a hub. I think in this front, we have to take it quite seriously, and our partnership should be in a long term, wherein the proposed Global South ADR Alliance, we expect your institutions, your academic bodies to partner, and we have to explore the greatest opportunity within the Global South. That's very significant. Thank you. Thank you, Mr. Harsh, for spending your valuable time so early in the morning. Being an initiative of 24 hours, your contribution is most valuable and commendable. As an academician, you always most welcome for our institution to take this task to the next level. Thank you.